And onto this now. The pre-sentencing hearing for economic freedom fighters leader Julius Malema has been postponed to the 15th of April. Last year, Malema was found guilty of contravening the Firearms Act after he fired live ammunition from a weapon at a 2018 party rally. And during Friday's proceedings, the defense made several arguments for a suspended sentence and called a social worker who read a report supporting Malema should not serve time. The state, however, pressed for a lengthy imprisonment, citing the severity of the offense and saying it would set a precedent for people being allowed to evade consequences for their actions. Let's discuss the merits of arguments with legal analyst Abigail Ngobene. Thank you so much for joining us, Abigail, and welcome to Newzroom Afrika.
Good morning to you, Ms. Chaba. Good morning to the viewers of Newzroom Afrika. Thank you so much for having me.
Now, firstly, for our viewers who may not be fully aware, can you just walk us through the charges that Malema was found guilty of and why are they considered serious under South African law?
Well, thank you so much. You'd remember that this is a long and the matter that have been going on for so long. And Mr. Malema, we are aware that he has been found guilty of a possession of a firearm, as well as the discharge of such a firearm in a charged up place. And on all these charges that he has been convicted of course, stems out from the Firearms Controls Act, which particularly its mandate is to ensure that there is a responsible use of firearm. The unlicensed firearms are eradicated from the community for the purposes of the safety of the community. That is amongst the others that he was convicted of.
Now, Abigail, what exactly is the purpose of a pre-sentencing hearing and what does the court consider at this stage?
Well, the pre-sentencing hearing is for both parties to come and make presentations before the court, outlining certain aspects that the presiding magistrate or a judge should take into consideration before arriving at what he or she deems as an appropriate sentence. And under the circumstances, of course, we have heard from the side of the defense through the witness that they called to present personal circumstances of the accused and other things that, in their view, they think the court should consider to arrive at what would be a proportional or appropriate sentence. And of course, that is the purpose for the pre-sentencing proceedings.
Now, this case stems back from an incident that happened all the way in 2018. 2018, 7 years ago. What's taken so long for this case to get to this point?
Well, there have been a lot of things that were going on in as much as I did not follow it to the T. But of course, in a trial matter like that, you would expect that many factors have played an effect. You'd remember that this matter has been a matter that has a participation of parties whom I will deem as seasoned attorneys, or rather seasoned legal practitioners, whose diaries will forever be full. And for the matter to proceed, it requires all parties, the availability of all parties for it to continue. So it has been going on. And of course, it also has to deal with the issues of witnesses that have been presented, the amount of evidence that have been presented, the challenging of such evidence, of course, because you understand that any person who is facing criminal charges, in terms of the criminal justice system, it functions in a way that it affords anyone ample time, enough time for them to present their case.
Sure.
So I cannot really say it's something that can pin on one party, but of course there are many factors that took place for it to take so long.
Right,
but eventually the matter came to its finality.
To get more clarity now, the matter was postponed to April 2026. From a legal perspective, why would a court postpone sentencing after a conviction?
Remember that it's not just a matter of getting straight to the sentence. Now that the defense has presented evidence in mitigation, the state has to present their submissions for the purposes of aggravation. And all those matters and factors that will be adduced there will have to be considered holistically by the presiding magistrate to arrive at a particular decision. And moreover, if they make presentations such as case law, they need to afford the presiding magistrate an opportunity to apply her mind thoroughly on what is presented before her, to also align herself to the triad of considerations that are outlined in the State versus Zin, to see to it that those factors come into play to arrive at what is an appropriate sentence. So postponing the proceedings for a sentence is normal.
Oh, I see. All right. Because, what I really wanted to know is postponement in a case of this magnitude like procedurally normal? Does it suggest complexity in sentencing? Is there anything happening behind the scenes? Now, let's talk about this. Like the minimum prescribed sentence for unlawful possession of an automatic or semi-automatic firearm is reportedly 15 years in prison. Is that sentence mandatory, or does the court have discretion here?
You'd remember that in a sentencing proceedings, the court has a discretion to arrive at what is a proportional sentence. You remember that there's many case laws that says that in an event of a sentencing, the sentence must be proportional. It must meet the offense. It must meet the seriousness of the offense that have been committed or that the accused have been convicted of. So it is something that this court, of course, would come to apply its mind on whether or not it goes with the minimum sentence. But in law, when the legislature have made minimum sentence, there must be serious compelling circumstances that allow the magistrate to deviate from that. So let's rather wait and see. It is a minimum for the magistrate or the judge to follow that prescribed sentence. But where there are compelling circumstances, such a sentence can even be lesser. But such reasons must be very convincing and be very serious to deviate from the prescribed minimum sentence.
And on that note, before we let you go, how do courts balance a person's social contributions against the seriousness of a criminal offense, particularly in firearm-related cases, such as this?
You remember that there is a long outstanding, or rather a long established principle in the State versus Zin that outlines 3 factors that the court must take into consideration when it arrives at the sentence. 1 is the interest of the society, 2 is the seriousness of the offense, and another one is the personal circumstances of the accused. So in any case where a sentencing is taking place, the court will always balance these 3 factors. In this case, it's going to be treated in its merits. You'd remember that the witnesses outlined a lot of things: the upbringing of the accused, his political standing, and all other things that have been adduced to say the court must consider to arrive at a non-custodial sentence. But it's not the only thing that the court consider what has been submitted by the witness. The court is going to apply its mind. It's going to follow the principles in Zin. It's also going to ensure that it checks the issues of remorse on the side of the accused, even though the remorse is not a central issue. But there are those things that are unique in nature that the court will have to consider to check on whether or not the sentence that it will impose meets or is proportional to the crime convicted of.
All right, Abigail, thank you so much for your time. Let's wait and see what happens.